fourth is the more traditional process of attorney representation. And of course, there are many levels of attorney representation. But basically, that process is that each side, each party, hires an attorney to represent them in the case, and the attorneys then really direct the process. Presumably, that process is going to begin with some negotiation between the attorneys to see whether they can come to an agreement, and the parties may be actively involved in that negotiation process as well. If negotiation between the attorneys fails, there is also a explicit effort by the courts to try and settle cases, and in fact, most cases do settle without a trial or a formal court proceeding. And there are settlement processes encouraged by the public courts as well as private judges who are available to assist parties with settlement. So if the attorneys are unsuccessful in negotiating a successful resolution, the parties and their attorneys will then enter into a settlement process, either with the assistance of the public courts or with the assistance of a third party that the attorneys may have hired specifically to assist them with settlement. Litigation is the formal court process when your attorneys will be going to court, filing papers, and presenting the case to a judge for a decision. Litigation is the most formal and the most expensive side of the spectrum of all the processes that we've talked about, but there are some matters that simply need to be litigated and need to be resolved by having a judge make a decision. The process of negotiation, settlement, and litigation are not necessarily sequential as I've described them. It may be that you start with litigation and then move to negotiation and back to settlement and for more litigation. So these are all facets of the attorney representation process. The style of the attorney and your relationship with the attorney will be critical in terms of your experience of a divorce process based on attorney representation. The attorney really represents the client in the fullest sense. The attorney will be responsible for conveying what's important and for really telling the client's story and negotiating the terms of the settlement. Sometimes the style of the attorney may be very litigious, and I've often had clients say, well, I can't believe that my spouse is really supporting that kind of litigious action by his or her attorney. But what I've found is that people do have a way of finding attorneys that carry out their agenda, and aggressive action by the attorney generally reflects that desire in the parties. And certainly if your attorney is acting in a way that is not consistent with your desires, then you need to speak up and let them know that. The biggest advantage of attorney representation is that you have full protection and full advice every step of the way. And the biggest disadvantage is that it is an expensive process and it is potentially a destructive process for the relationship. I want to spend some time talking about the attorney-client relationship because it is such a critical relationship in any of the processes that we've discussed. First of all, finding a lawyer. There are several ways that people find lawyers, and it's helpful to ask your friends for referrals. There are also lawyer referral services that will give you information about how to find a lawyer. And other professionals that you work with, your accountant or your financial advisor, your psychologist, or even your priest or minister might be good sources for attorney referrals. If you call several sources, you'll find that some of the same names come up more than once, and those are good indications of strong referrals within the community. Then I think you need to proceed to interviewing some of the lawyers, and that may simply mean calling their offices, finding out what their availability is, what their fee structure is, and a little bit about how they operate. I think that in terms of selecting a lawyer, you need to ask questions about the lawyer's experience in handling family law cases, and particularly cases with the kinds of issues that you are dealing with. If you are going to have a complex custody situation, for example, with a potential move away from the area, you want to know if that attorney has handled move away cases. If you have a complex financial issue such as stock options that need to be divided, you want to know what that attorney's experience is in dealing with stock options. In California, there's also a certification of family law specialists, so you can ask whether the attorney is a certified family law specialist. You can find out how many years of practice and also how much of their practice is in the area of family law. And I also think it's important to have an attorney who's practicing in the county where your case is proceeding. It is important that you also try to find an attorney with the right level of expertise, and that will affect your fees. If you have a fairly straightforward case, you may not need the most expensive attorney in town, whereas if you have a very complex case, you want to make sure that you have the level of expertise necessary. In terms of working with an attorney, generally I take a team approach in that I expect to have the client be a member of the team, my staff is a member of the team, perhaps other attorneys in my office might be of assistance, perhaps an accountant or a therapist or a financial advisor. So we want to create all of the supports that the client's going to need in the process. And that also gives you the opportunity as the client to access resources at several levels. So you always want to start with the least expensive person on the team. And depending on what your question is, it may be a question that can be answered by the legal secretary or legal assistant as well as the attorney, and that will save you some money. Another important part of the attorney-client relationship is the fee structure. And as a professional, your attorney is going to expect to be paid. So it's important that you understand the fee structure and how the fees are determined, and that you're willing to abide by the commitments that you make about the fees. Generally, the attorney is going to charge on an hourly basis, so you need to know what the attorney's hourly rates are, and you need to know the rates of other people in the office that may be working on the case. This is an area, again, where it's important to get the right level of expertise for the issues that you have in your case. Most attorneys are going to ask for a retainer at the beginning of the case, and that simply is an amount that is deposited into the attorney's trust account and then applied against your bill until it is completely used up. If there is money left over, usually that retainer is a refundable amount, and it's important that you know whether it is in fact refundable. Generally, after the retainer is used up, the attorney will ask that you replenish it, or they may ask that you simply pay your bills on a current basis. And again, it's important that you understand the fee structure and you're prepared to make payment as agreed. Most attorneys will also charge for an initial consultation. I do, and I think it's one of the most helpful sessions of advice that I give. It gives me an opportunity to understand a lot about the case and to give some very good advice about how the case is likely to proceed and how to structure the process at the beginning to avoid some of the problems that we've talked about. Like with any professional, it's important that you express your appreciation to your attorney and to their staff, and that will stand you in good stead with your attorney.
The question often arises when parties are first thinking about a divorce as to whether or not they need to be represented by a lawyer. Obviously, there's a cost involved in that, and if it can be avoided, that's fine. But in most cases of any real dispute over character of assets, support, sometimes child-related issues, it's very hard to proceed without a lawyer. One of the benefits of using mediation as the method of resolving your divorce is that you have the opportunity yourself to make a decision as to who the mediator would be, and by talking to potential mediators, by talking to references they may have, you can come up with someone who you feel comfortable is knowledgeable about the kinds of issues that are in your case, and who will be compassionate and helpful to you in helping you and your spouse to reach your own agreement as to how the case should be resolved. And that's just so much more beneficial to you. The atmosphere is much different than in the adversary court system. and also you are keeping the power to make your own decisions about your own life. And with all due respect, you know more about your life, you know more about your children, you know more about what your needs are, what the future may be, than a judge who hears your case for the first time, not knowing you, not knowing anything about the case, whereas the mediator can spend the time with you to become knowledgeable about you, about your case, and about what the expectations of each of the parties are. So I would urge you to think very seriously about trying an alternative method rather than going directly into the court system. The courts really should be the last resort, not the first resort.
We've talked about a number of processes, and the processes are not mutually exclusive. You can always begin with a less formal process and move to a more formal and more protective process. It's more difficult, however, to start litigation and to then move in the other direction, though I have had cases where people have been in litigation and then have contacted me to see if I'm available to help mediate it. How you approach the divorce will have a huge impact on the result and the process. It will likely be a year of your life, and very likely could be longer than that, so it's important that you choose the process carefully.